Thank you for staying with us here on the National Communications Network. My name is Shaquan Gill, and you're tuned in to another program of the Parliamentary Agenda, where we highlight the legislative activities of the government of Guyana. Joining me for a special discussion today, ahead of Wednesday's parliamentary sitting, is none other than the Attorney General and Minister of Legal Affairs, the Honorable Anil Nandlall. Minister Nandlall, thank you so much for joining us.
It's a pleasure to be here. Thank you.
Now, Minister, we're looking specifically today at the Acquisition of Land for Public Purposes Amendment Bill. Now, this is a bill that everybody, I think, at this point may know rests in the global principle of eminent domain. But this is not a new act. Share with us from your perspective how this act originated and how it was used even in earlier times.
Thank you very much, Shaquan. And again, thank you for affording me the opportunity to appear on this program. So, the Acquisition of Land for Public Purposes Act, it's not a new legislation.
Right.
It has been with us since colonial times. In fact, it was enacted first in England in 1914. So it's over 100 and more years old.
Yeah.
Of course, it became part of the laws of Guyana when we became independent in 1966. So from the birth of our country, we have had this law as part of the legislative landscape of our country. It is a law that is in almost every democratic state. It is a law that authorizes the state to compulsorily acquire private property for public developmental purpose. It proceeds on the principle that the state maintains an eminent domain over all lands within the territory of the state. And though titles may be issued to persons within the state, denoting them as owners of that particular piece of land for which the title relates, the state maintains an overarching and overriding power that is called the eminent domain to be able to repossess and retake that land, repossess and retake because the state originally had always owned the land. So it's a power to take back land from private ownership for the purpose of a public project or a developmental project for the public good.
Mhm.
It is a necessary power for developments to take place in any country. And countries all over the world have ensured that within the repertoire of every independent state is this power. Why? Governments exist to do things for the public good. And if a particular project has been identified for the public good, the principle is that the interest of one or a few must bend and bow to the glory of the public good. So if, for example, a highway is required to be built that will be used by the entire citizenry of the state, or a hospital is to be constructed that will provide medical care for the entirety of the state or a large section of the citizens of that state, and there is no land available for the construction of that highway or the hospital, the state reserves a power to take the land from the private owner and convert it into public lands for the construction of that particular undertaking.
Yeah.
The safeguard that the state guarantees in every case when this exceptional power is being exercised is that the owner of the private property or the private owner must be compensated adequately for the taking of possession and ownership of his or her property. And the principle upon which the compensation is computed is not that he must get a profit, but he must be justly compensated for the value of the land.
I want to pause you there, Eugene, for the value of the land, which I would assume to be fair market value at the time. Has it always been that way in the law?
No. In Guyana, no. In Guyana, until about 3 decades ago, this very law that was here for the past 100 years pegged compensation at a 1938 valuation. So citizens of this country who are older would know of the many controversial cases where the government of the day, and I'm speaking specifically of the PNC government, because the law was changed when the PPP came into government. So from 1966 all the way to about in the 90s, the law was the state could have acquired private property, but instead of paying adequate compensation, the state was obliged to pay a compensation fixed by the law to a 1938 value. So the state acquired many properties in the 70s and 80s, including Tacuba Lodge, that currently houses the Ministry of Foreign Affairs, Hope Estate on the east coast of Demerara, and the property where Citizen Bank is on Camp Street, or used to be on Camp Street. These are all private properties. They were acquired, but at 1939 valuation was what was supposed to be paid. In many instances, it was not paid. The Citizen Bank property, for example, in 2011 or 2012, that matter wound its way all the way to the CCJ, the Caribbean Court of Justice, and that court ordered this government, our government, to pay some $40 million in compensation for the acquisition of that property that took place in the 70s. So although the compensation was pegged at a 1938 value, it was never paid. And the land was never used, the property was never used for the public purpose for which it was acquired. You see, the law is very strict. You have to state what is the public purpose. And then you have to ensure that the land is used for that public purpose and not for another use. That property was never used for the public purpose for which it was acquired. And I don't want to call people's names on this program, but there are many other Guyanese whose properties were acquired during that period, and the compensation was never paid. Neither was it used for the purpose for which it was acquired. Decades after these proceedings were filed, and our government returned the property, in many cases, to the original owners.
Yeah.
Because As I said, they were never used for the purpose. In fact, people were left in the property. The state never, they just took the title to the people's property. So the differentiating thing about then and now is one, the property value was pegged at a 1938 value. And secondly, the compensation was never even paid. And I could add a third. The properties were not used for the purpose for which they were acquired. In those circumstances, the court ruled repeatedly when these challenges came up that look, the properties were never properly acquired and ordered the reversion of the title back to the private owners.
Yeah.
So that was the state of the law in Guyana. That position has radically changed.
And
I'm going to get
Yeah.
to that in the course of the discussion.
Of course. So I want to look at today's, or rather, the amendments that are going to be debated in the National Assembly later this week, particularly in relation to Bill number 16 of 2024. Now, Section 7.1, and the amendment that is going to be made of Section 7.1 seeks to, as the explanatory memorandum says, quote, guarantee the state's right to begin using the land for state purposes. Why was there a need by the government or from the government to do this?
So, perhaps a good place to begin is to quote the Constitution itself, right? Because it's the Constitution that guarantees protection to private property. So, if the state is going to take the property, the state must comply with the Constitution. So, the Constitution itself must authorize the taking of the property. As you know, private property is protected by our Constitution. So this is what the Constitution says on the matter. Article 142 of the Constitution. Every citizen has no property of any citizen of any description, no property of any description shall be compulsorily acquired, taken possession of, and no interest in or right over property of any description shall be compulsorily acquired, except by or under the authority of a written law. And where provisions applying to that taking of possession or acquisition is made by a written law requiring prompt payment of adequate compensation. So the Constitution itself permits the state to take property by compulsory acquisition, but must do so under a written law that authorizes prompt and adequate compensation. This law is that law that the Constitution is talking about. We have not added any additional power to this law that is 100 years old. No additional power is given to the state by this amendment. None. I listened to all manner of distortions being peddled in the press, and we will deal with them.
Of course.
But the impression that is being conveyed is that the government is moving to the parliament for the first time to introduce this law, to authorize the state to take private people's property. An absolute distortion and misrepresentation. That power has been with the state from its birth. And no additional power is given to the state in these amendments. None.
AG, critics of the government are saying that this bill seeks to enhance state control, as we're referencing, to remove people from their lands unilaterally. And some are saying that this particular amendment disenfranchises people of African descent. I'll ask you very strictly, plainly rather. Is your government out to treat Afro-Guyanese unfairly and unequally via these amendments?
So let's take them one at a time. This law as I said, Section 7 is where we are amending, right? We are adding, we are making three amendments to Section 7. One, and let me read it so that the people will understand. Section 7 is amended by inserting before the word payment the word prompt. So wherever the state has an obligation to pay, the state must do so promptly. Isn't that for the benefit of the citizens? You're getting prompt payment. Under the old law, the state had an obligation to pay. We are now saying that the state must pay promptly. What promptly mean? Immediately. How can that be objectionable? I am strengthening the law for the benefit of the citizens. Secondly, the second amendment is that by inserting immediately before the word compensation, the word adequate. Right now, the law says you must pay compensation. And I am not prepared to leave it at that. I am saying, for the avoidance of doubt, you must pay adequate compensation. How that can be objectionable? Isn't that again for the protection of the property owner? I am compelling the state to pay you promptly. This is a power that the state already has. I am now putting an additional burden on the state to pay promptly when you acquire the property and to pay adequate compensation when you acquire the property. How can that be inimical to the property owner's interest? The point I am making to you is that these people who are spewing this nonsense, either they have not read the law, the amendment, and they have not read the law, or they have read either or both, and they don't understand what they are reading. There is no other conclusion I can come to. The third amendment is, let me read it in its entirety. Section 7, 2, Section 7, 1. At the expiration of 1 month from the date of the order mentioned in the last preceding section, that is the order that the state will take the land, or any longer period fixed by the order, the land specified therein shall vest in the state. That is already the law. When you publish the publication, the land is vested in the state, subject to the payment of the purchase money or any compensation, subject to the prompt payment now of the purchase money or any adequate compensation as hereinafter provided. And the act sets out how the compensation must be paid. All we are doing now, in addition to adding prompt and adequate, we are saying now that provided, after the word provided, we are adding the word, but without prejudice to the state's right to vacant possession of the land. So all we are saying is that when the land is vested to the state, it remains subject to the payment of adequate compensation. Nothing is changing in that. But without prejudice to the state's right to vacant possession. In other words, the title must vest in the state's name, and the state must get vacant possession at the same time. Does it make sense that the state is going through all of this, is going to take the land, and then can get possession? If the state is owning the land, that's what the thing says. The title is vesting in the state. Once you own an incident of ownership is possession. It was unclear, at least the judges of our courts feel so. We are clarifying it now. When the state owns it, the state must possess it. Have you ever heard of a situation where a man owns, but by law he cannot possess? How can you own land but not possess it? Not be entitled to vacant possession of it? It runs counter to ownership. The only way you can own but not be able to possess is that if you yourself have agreed that you will accept possession at a later date. For example, you permit somebody to stay in the land after you own it, or you rent it to somebody, then you are parting with possession of it. But once you own something, you are entitled to possess it, and that's all that this is seeking to do. So now, when you compare this with other legislation across the region, and I have Trinidad here, I have Belize, I have Jamaica, and I don't want to read and bore the audience, but in these jurisdictions, the laws of these countries authorize the state to possess even before it owns. Our law puts the state in ownership first, and then possession follows. Anyone who have researched this area, they've looked at those countries, you will see that in each of these countries, there is a power in the minister to possess the land even before ownership is given to the state. Of course, in every case, compensation must be paid. That's a given. But the law contemplates the situation, and rightfully so, that compensation is not always agreeable, the value of the compensation. Yeah, right. So, in the event that there is a dispute, the law provides for the court to settle that dispute. But in the meanwhile, the state must take possession. That is what this law is seeking to clarify. In my view, the state has the possession already in the current law. But our judges feel that the situation is not clear enough. But if I own and the title is vested in me, how will I not be able to possess? Right. The law will not be so asinine as to give me ownership in the one hand under this exceptional eminent domain power, I being the state, but frustrating me from using the land for the purpose for which I'm taking it by not being able to possess it. Does it make sense?
So let me ask you specifically about one incident.
No, but you were asking me about Afro-Guyanese. Let me deal with that.
All right, go ahead.
You have read this law?
I have.
You read the bill?
I have.
And you read the Principal Act?
I have.
Did you see any mention of any ethnic group anywhere in this legislation?
I haven't.
Have you seen the word Afro-Guyanese mentioned anywhere?
I haven't.
So what this has to do with Afro-Guyanese?
So here is what some of the members of the, particularly Padaji, have said yesterday in an event that they had, particularly in relation to government acquiring land in the area of Peters Hall. One associate said that there were Indo-Guyanese in that area whose lands were acquired, and they were given, according to them, unfairly high compensation amounts when compared to lands owned by Afro-Guyanese.
My brother, people get value and compensation based upon the market value for their lands. if your house is valued $2 and three valuators, because we use three valuators, we didn't use the government valuation alone. We use another private valuator and a court ordered evaluator. So there were three valuators. And all three valuators were consistent. If they determine that the property is valued $2, that is what the state will pay. If your property value 50 cents, as determined by the evaluators, that is what the state will pay. Not all properties are equal in the country. You have properties that value $100 million. You have properties that value $500,000. You want the property that value $500,000 attract compensation for $100 million?
Attorney at Law Darren Wade said that the government is also refusing to submit some of these agreements that we are referencing, pursuant to an order by Justice Kissoon in an ongoing court case. Is there any truth to this, AG?
Justice Kissoon has made an order that certain compensation packages that we have agreed to be submitted to him. These are people's private business. The people are objecting to their valuation and their compensation packages be made public like that. That's not a matter for the state. So we are dealing with that matter is still in the court. Tomorrow actually is the case. But you can't look at another man's valuation and be covetous of it. You have to look at what your property is valued. We have many, I don't want to categorize the thing on the basis of ethnicity.
Right.
You have Afro-Guyanese who have gotten $80 and $90 million. You have Afro-Guyanese who have gotten 20 million as well. We have Indo-Guyanese who have gotten 20 million. We have Indo-Guyanese who have gotten 110 million. It depends upon the value.
Right.
And as I said, three evaluators have given opinion on these matters. And the judges have ruled that, none of these decisions have been appealed by the persons who have received their compensation. And this is not the government doing this for the first time. We did compulsory acquisition for the Berbice Bridge. We did compulsory acquisition for the Hope Canal. We did compulsory acquisition for the entire pipeline from Crane Seawall all the way to Wales. We did compulsory acquisition for the Schoonard to Crane Highway. You're talking about hundreds of properties. The same method that we have used is what we have used across the board. There are about 3 or 4 persons here at Peters Hall who are raising this objection.
Mm-hmm. I want to address Section 24A, AG. And in the conversation that happened just a few days ago, there was a concern, particularly in relation to the terminologies used in 24A regarding, quote, interested and authorized person. One attorney says that this opens the door for fraud because this is not defined in the legislation. Why did your drafters choose this language?
My friend, first of all, let us understand what 24E does. Under the current law, if compensation is not agreed to by the parties, 24, section 24 in the current law, allows the government to take the land and issue to the property owner or the person standing in the shoes of the property owner or the person entitled. The property owner may be dead. So that I will get to what interested party means just now. Section 24 allows now no, sorry, let me go back to what the Section 24 says in the law. It allows the minister to issue a bond. For them to hold that bond, the government will take the land, develop the land, do whatever it wants with the land, until the court determines the case, and then you will be paid.
Mm.
In the meanwhile, you're holding a bond, a piece of paper. Section 24. Now, instead of permits the minister, instead of giving you a bond, a piece of paper, to actually give you the money that the state is offering.
Mhm.
80% of the money you can get until the court determines it. How can that be bad? You want me to leave you with a piece of paper in your hand that you can't do nothing with? That is the current law. Giving you a bond, you can't do anything with it.
Mm.
I am giving, the law now is giving you cash money. Maybe that is something that you want, but it's something that the government is offering that you can now, because you have, the land is already with the state. The only question now is how much money you're entitled to, and we are giving you a cash advance now, rather than give you a piece of paper that means nothing to you. You see how these people are reading and deliberately distorting, or they cannot understand what they're reading? Now, who is an interested party? My friend, this is what 24 says. Where any land is acquired under this act, an interested or authorized person may make a request to the minister for an advance payment on the account of any purchase price or adequate compensation payable under the act. So it's an advance you're getting.
Mhm.
And if the minister is satisfied of proof of title, the minister shall promptly pay in advance in respect of the request. And any interested person can come forward. Now, obviously, it says one, and if the minister is satisfied of the proof of title. Is that any? Is that the whole country can come forward? Is an interested person, a person who stands either the title holder or a person who stands in the shoes of the title holder. If the title holder is dead, an interested person means a person who can receive the money on behalf of the deceased. If the title holder is in America or in Canada, an authorized person is a person who can come and produce a power of attorney and said, I am the authorized person of the title holder. The thing says the once the minister is satisfied of the proof of title, meaning the minister has to satisfy himself that there's a connection between you, who is presenting himself for payment, and the title to the land. I don't teach. This is not any common entrance school student could read this and understand it. Where is the mischief? What are they seeing here? Government should be complimented for this bill, every aspect of it. Not criticized. These people are, I don't know, they are bent on misleading and perverting the provisions of this bill. And that's why I'm convinced that either they have not read it, or having read it, they don't understand what they have read.
AG, if we were to stick a little bit on 24A, that speaks about the satisfaction of the minister when it relates to proof of title. The concern has been raised, particularly by Ipadaji and others, in relation to ancestral lands that somehow have connections to Afro-Guyanese. Does the law in any way cater for this kind of scenario?
First of all, I don't know what is ancestral lands. None of them can explain what ancestral lands is.
They say people who are inheritors whose foreparents have owned the piece of land that they may now be on.
But that applies to every race. How is that applicable only to Afro-Guyanese? Indo-Guyanese grandmother may have a transport and died, and nobody probate the estate, and the transport is left there, and I am left on the land. How is it that only isn't if that is what ancestral land is, isn't this ancestral land too? So once there is a title, it means that it is not public lands, it is not government lands. And if the government has to take the title and take it and give it to the state, then the government has to pay compensation for it. And that is why the term interested person is being used. Because if you are the last line of descendant of the owner, suppose that the legislation had said only the owner, well, then I would have been depriving the descendants. You see how these people are ignorant? The use of the term interested allows a wider category of persons who have some linkage to the original title holder can come forward. The law in its wisdom, it might be 10 people, it might be 10 persons who are equally entitled. The state will have to divide the purchase money or the compensation into 10 because each is qualified. The state should be complimented for using the term interested or authorized, not criticized. This is where we are accommodating every person who can show some legal connection to the land and who may not have the title in his or her name. So where is the issue? Where is the problem?
Yeah. As we wrap up our conversation for today, AG, I want us to maintain our attention on Section 24A, but look at subsection 6 that speaks particularly to lands that are in trust or settlement. Can you explain this particular part of the amendment and why this was included?
This is to cater for every category. You'll see the subsection before that deals with mortgage land. So if, for example, the state acquires land that is the subject of a mortgage, here the state is obligated to pay off the mortgage so that mortgagees' interests are not defeated. Remember, mortgage is a collateral,
Right.
is a security for a debt. If the state takes the property, then a bank that may have a mortgage on that property, the bank's secured interest is defeated. The owner, the person who took the loan, will now have an unsecured loan. That is why the amendment permits the minister, if the land is subject to the payment of a mortgage, to pay off that mortgage. If the land is subject to a trust, you can't defeat the trustees or the beneficiaries of the trust. Immediately, the land is going to somebody. You should pay those persons. That's all that it means. To ensure that whoever is entitled to the land futuristically gets the benefit of the compensation because you're taking ownership of the land. The state is taking ownership. And each category under 24 contemplates a different factual situation. Because when you're crafting a law, it must cover all the eventualities. And no category of persons entitled should be left out. These persons here who are criticizing, they don't have an idea. That is why the word interested is used, to bring in the widest category of persons. But that those persons, no matter how many they are, they have to show a connection to the titular owner. Is that any person can walk off the street and come and collect compensation? If it is that is Mary Jane land, and you claim to be along the bloodline of Mary Jane, well, you have to come and show that. Mary Jane was my great grandmother. This is the line of documents that show that. You understand?
I understand.
So, in conclusion, there is nothing, absolutely nothing objectionable, pernicious, harmful, disadvantageous, or in any manner whatsoever deleterious in relation to these amendments. These amendments lean towards the protection of private property rather than its deprivation or diminution. They are good amendments and they are intended to protect the rights of the Guyanese people. The only change that this thing does is that it gives the state immediate possession once the state acquires the property, so that one person cannot hold back an entire project. That is all that it does. And those who are misinterpreting and misinforming are trying to fabricate and manufacture a controversy where one doesn't exist.
AJ, I want to thank you so much for spending the last few minutes with us, sharing, detailing, and explaining this piece of legislation. Thank you so much.
Thank you very much.
You've heard from the Attorney General and Minister of Legal Affairs, the Honorable Mohabir Anil Nandlall. Be sure to tune in to the National Assembly sitting on Wednesday, starting from 10 a.m. My name is Shaquan Gill, and I'm saying goodbye for now.